This is Lesson 7, the Law of Contract, Chapter 10. And we have question 1. Latent defects are defects which are unknown to the buyer and are so material to the enjoyment of the property that he might not have entered into the contract had he or she known that they existed. Latent defects are those which are... For none of the above statements describe latent defects. So we got 1. Immediately visible to the eye of the average person. 2. Discoverable upon a reasonable inspection of the property. 3. The responsibility of the licensee to discover. So the answer is 4. None of the above statements describe latent defects. Question 15. On May the 3rd, Mary offered to buy Harvey's house, and the offer was stated to be open for acceptance until 2 p.m. May the 4th. Which one of the following statements is false? And the answer is 2. Mary's offer represents an option agreement. All right, that is totally false. Mary's offer is not representing an option agreement, okay? These other things are true. 1, she can revoke her offer prior to 2 p.m. on May the 4th. Yes, because that was the due date. 3, if Harvey makes any changes to the offer, Mary's original offer is terminated. Yes. And 4, if Mary mails a notice of revocation to Harvey, the offer is only revoked if the notice is received by Harvey before he accepts. So, those ones are true, but the false one is 2. Mary's offer represents an option agreement. And we've got page 2, number 25. Zelda was in a good mood one day, and she went over to her next-door neighbor Herb's house and cleaned all his gutters. When Herb returned home from work, he was thrilled by what Zelda had done, and he said, "Zelda, I'm going to give you a case of wine for doing this." Weeks passed, and finally Zelda asked Herb when she could expect to receive her wine. Herb said that he had changed his mind. Zelda is now furious and wants to sue Herb in small claims court. Which of the following statements is most relevant to these facts? And the answer is 3. Past consideration is no consideration. All right, so that's the answer. 3. Past consideration is no consideration. Question 37. A revocation of an offer is effective when 2. It is communicated to the offeree. So a revocation of an offer is effective when 2. It is communicated to the offeree. Question 56. The court will not normally grant the remedy of specific performance when 3. Damages are considered to be an adequate remedy. So 56. The court will not normally grant the remedy of specific performance where 3. Damages are considered to be an adequate remedy. All right, and then we go to page 3. We've got number 66. A owes B $1,000. B assigns the debt to C. For this to be a statutory assignment, 3 requirements are necessary, and which one of the following is not one of them? And the answer is 4. The notification from A to B must be in writing. So that, let me see, the notification from A to B must be in writing because A is the one who owes, B is the one who lent out the money. So that thing is not one of them. But the other 3, 1, 2, and 3 are correct. 1, the assignment from B to C. So it means the lender to a third party must be for the entire amount. 2, the assignment from B to C. That means the lender to the third party must be in writing. And 3, the notification from C, the third party, to A, which is the borrower, must be in writing. So those things are true. But number 4 is false, and so it's not one of them. So 4 is the answer. The notification from A, the person who owes the money, the borrower, to B, the lender, must be in writing. No, it doesn't make sense. Question 78. Which one of the following is not a requirement to establish misrepresentation in contract law? And the answer is 4. The assertion must be in writing. So this is not a requirement. You get that? It's not a requirement to be misrepresentation in contract law. It must be in writing. No, it doesn't need to be in writing. But 1, the assertion, there must be an assertion of fact, yes. 2, the assertion must be false, yes. And 3, the assertion must have been material to the formation of the contract. Okay, those things are all true. But the thing about the assertion must be in writing, number 4, is not a requirement. Question 83. Which of the following is not an example of a breach of contract? And the answer is 1. After Don contracted with Tony to buy his car, the night before Don was supposed to pay the price and take the car, it was struck by lightning in Tony's driveway and destroyed. This is not a breach of contract. Lightning does not breach contract. Okay? But all these other things are breach of contract. 2, after Babs contracted with Quinn in May to rent his motorhome for 1 week in July, Quinn telephoned Babs and told her that he was going to use the home himself that week and that she would not be able to rent it. So that's a breach of contract. 3, Fred contracted with Jordan to sell him his collection of hockey cards. But 1 day later, Fred sold them to Andrew, who paid him $15 more than Jordan had agreed to pay. That's a breach of contract. And 4, Adrian contracted to paint Woody's house starting on September 1st for a price of $500. On September 1st, Adrian failed to turn up and did not return any of the messages that Woody left on his answering machine. Those are all breaches of contract. But what is not a breach of contract is Tony buying Don's car and it being struck by lightning in Tony's driveway. Question 112. Which one of the following statements about the revocation of an offer is true? And the answer is 2. Unless consideration is paid to keep an offer open for a specific time, revocation can be made at any time prior to acceptance. Okay? So you can revoke any time unless a specific time is mentioned. Page 4. Question 167. Which of the one of the following is not a remedy for breach of contract? And the answer is 4. Rectification. That is not a remedy for breach of contract. But all the other ones, 1, damages, 2, specific performance, and 3, injunction, those are remedies for breach of contract. Question 199. John makes the following offer to Mary. He says, I will pay you $500 to put a new rose garden in my rose bed in my garden. If Mary accepts, what is the result? The result is 3. An enforceable contract has been formed if an intention to create a legal relationship exists. So basically, under law, if John says to Mary, he says, I'm going to pay you $500 to put a new rose bed in my garden. If Mary accepts, then 3, an enforceable contract has been formed if an intention to create a legal relationship exists. Yes. Question 201. When a contract is executed under seal, the seal 3 stands in the place of consideration. And that is true. When a contract is executed under seal, the seal 3 stands in the place of consideration. And we turn over to page 5, and we're dealing with 205. Avoidable contract is, and the answer is 2, a contract which one of the parties can cancel. So that is the truth. Avoidable contract is 2, a contract which one of the parties can cancel. All right? 263. Bob and Margaret execute a contract under seal. Because of this seal, 4, there is no need for consideration. Do you get that? So 263, Bob and Margaret execute a contract under seal. Because of the seal, 4, there is no need for consideration. Seals are magical. Question 266. S, a seller, offers to sell a property to A for $50,000. The offer is to remain open for acceptance until noon the next day. At 11 a.m. the next day, B offers to purchase the same property and S accepts. At 11:30, A accepts the original offer. And which of the following statements is true? The answer is 4. All of the above 3 statements are true. And what are all the above 3 statements? 1. S has entered into a contract with both A and B. 2. S could have revoked the contract. S could have revoked the offer to A and avoided the problem. That would have been better. And 3, both A and B are entitled to contractual remedies against S under this scenario. So yeah, they both are owed something. So 4, all of the 3 statements are true. Amazing, huh? And we go to page 6, question 277. On March 7, Alan contracts in writing to sell his home to Bob for the price of $100,000. The sale is to complete on March the 31st. Unknown to either Bob or Alan, the home was destroyed on March the 6th. Accordingly, there has been, and the answer for 277 is 3, a common mistake. So the answer here, the house is destroyed on March the 6th, and then a day later they contract to sell it, and there's been 3, a common mistake. They didn't know it was destroyed. Obviously, Alan is not living in the home. 286. A subject to clause in a contract of purchase and sale is correctly known as, number 1, condition precedent. Subject to, the other name for that subject to clause is called condition precedent. Not President Obama, but condition precedent. That is subject to. 295. As a general principle, which one of the following is the proper method of communicating acceptance of an offer? And the answer is 2, in the same form as the offer. So generally, the best way to communicate acceptance of an offer is 2, in the same form as the offer. All right? Whatever the form of the offer was, you do it in the same form. So we go to page 7 and we have 320. Latent defects are facts which are unknown to the buyer and are so material to the enjoyment of the property that the buyer might not have entered into the contract had he or she known that they existed. And answer 4, the defects are not discoverable upon reasonable inspection of the property. So I don't know. Can you say that ants? Maybe you dug around for ants, you couldn't find any, you say, hey, there are no ants. But the ants were like, deep in the ground, and then they came out later. So anyways, this thing is about latent defects. They are facts which are unknown to the buyer, but they are so material to the enjoyment of the property that, the buyer may not have entered into the contract had he or she known they existed. So 4, the defects are not discoverable upon reasonable inspection of the property. Yeah. You know that? They're not discoverable upon reasonable inspection of the property. Question 332. An invitation to treat is, 1, a request for offers. So, for example, a billboard advertisement, that's an invitation to treat. So it is, 1, a request for offers. Question 348. Where an offer has been made by post, an acceptance by post will be effective, 1, when posted. So if you make an offer by post, if you accept it by post, it will be effective, number 1, when posted. 369. A counteroffer has the effect in law of, number 2, terminating the original offer so that later it cannot be accepted. So when somebody gives a counter offer, Legally, it is number 2, terminating the original offer so that later the original offer can't be accepted. But the counteroffer can be accepted. And then we're moving along to page 8. Question 398. Generally speaking, a contract cannot be enforced against an infant unless, 398, number 4, all of the above will make a contract with an infant enforceable. And what are all of the above things? Number 1, the contract is affirmed by the infant after he reaches 19 years of age. 2, the infant performs or partly performs the contract within a year after reaching his 19th birthday or her 19th birthday. 3, the infant does not repudiate the contract within a year after reaching his 19th birthday. So there we go. All of these things make a contract enforceable. 1, reaches 19 years and affirms the contract. 2, performs the contract within the 19th year. And 3, doesn't repudiate the contract within the 19th year. So all of the above. Question 415. An offer is released or expires when one or more of the following occurs. And the answer is 4. Only B, C, and D. What is B and C and D? So B is no time limit is specified in the offer, but a reasonable time is passed without acceptance by the offeree. So then the offer expires if you don't specify a time limit. No time limit is specified. That's B. C, the offerer dies or becomes insane before the offeree accepts the offer. So that's another true thing. If the offerer dies or becomes insane, well, then the offer is expired. And then D, an offer is revoked by the offerer and the revocation communicated to the offeree before acceptance. So if the offer revokes it, then the offer is expired. So the answer is 4. Only B, C, and D are true. Question 446. Duress in law consists of, number 1, actual or threatened violence or imprisonment. So basically, law would state that duress, the whole thing about duress, is number 1, actual or threatened violence or imprisonment. We go to page 9, and question is 453. 453. Frank sends a letter to Joe saying, I will sell you 100 dozen widgets for $1,200. Before Joe receives the letter, he sends an email to Frank offering to buy 200 dozen widgets for $1,200. Okay. Wow, what a coincidence. Given this information, which of the following statements is true? And the answer is 3. There has not been a valid offer and acceptance, and therefore a contract has not been formed. So this is a weird situation. Frank sends a letter by post to Joe, and he says, hey, I will sell you 200 dozen widgets for $1,200. And so, before Joe receives this letter in his mailbox, he sends an email to Frank, and he says, hey, I will buy 200 dozen widgets for $1,200. So because there's this is given, I think, in a different communication form. 3, there has not been a valid offer and acceptance, and therefore a contract has not been formed yet. But I'm sure they will get it somehow. Number 455, Bernadette offers to purchase Steve's home for $438,000. However, before Steve has a chance to respond to the offer, Bernadette advises that she's withdrawing the offer. Which of the following legal terms describes what has occurred? And the answer is 1, revocation. So Bernadette offered to purchase Stephen's home for $438,000. However, before Steve has a chance to respond to the offer, Bernadette advises that she's withdrawing the offer. So this is, which of the following legal terms describes what has occurred? And the answer is number 1, revocation. Bernadette has revoked her offer. 472, Sally contracted to purchase sewing machines wholesale at $100 each, with a delivery date of November 30th. The wholesaler did not deliver the machines until December 31st. Sally had a buyer on November 30th willing to pay $250 each for the machines, but by December 31st, the value had dropped to only $75 each. Which is Sally's best remedy against the wholesaler? And the answer for 472 is number 3, damages. So Sally can seek damages because this wholesaler sent the machines like a whole month later when the value had dropped from a potential $250 to $75. So she can seek damages. Sally seeks damages. Page 10, question 496. Which of the following is not a required characteristic of an offer? And the answer is 3. It must be made in writing in order to be enforceable against the offeror. So this having an offer made in writing in order to be enforceable against the offer, that is not true. It doesn't have to be made in writing. But all the other things are true. 1, it must be made in clear and unambiguous terms. 2, it must demonstrate a serious intention to be bound. And 4, the terms stated must be clear enough that both the offeror and offeree clearly understand the extent of their obligations. Well, all those things are true. Clear, unambiguous, serious intention, clear enough to both parties. But number 3, it must be made in writing? No, that is not a characteristic. 515, if an offer is made by mail and the acceptance is mailed, when is the acceptance effective? And the answer is 515. Number 3, when it is posted. An offer is affected, the acceptance is effective when it is posted. That's number 3. 520, Garfield, a trading service rep, with the listing and selling rep, a representative with respect to the sale of Madison's house to Tyler. Okay, he was the listing and selling rep with respect to the sale of Madison's house to Tyler. After the sale completed, Tyler discovered that the main and lower floors of the house sloped. Garfield, Madison, and Tyler had not noticed this before, although the defect was discoverable using ordinary diligence. Based on the above, which of the following statements is true for 520? And the answer is number 3. Neither Garfield nor Madison are liable to Tyler, who just bought it, for failing to bring the defect to Tyler's attention. So, if this goes to court, neither Garfield, number 3, nor Madison are liable to Tyler for failing to bring the defect to Tyler's attention because they didn't know. Those idiots. Question 541. On March the 7th, Alan contracts in writing to sell his house to Bob for the price of $100,000. The sale is to complete on March the 31st. And on March 8th, the house is destroyed. Accordingly, there has been 541, number 2, a frustration of the contract. So the answer is there is frustration of the contract. And why is that? Because now, if the house was destroyed while they were deliberating and they hadn't signed the contract, then we could probably call it a mutual mistake. But because they had already seen the house, everything was great on March the 7th, they put it in writing, and between March 7th and March 31st, the house was destroyed, actually on March 8th. So that is frustration of the contract, number 2. And then we go to page 11, question 575. Charlotte offered to sell her property to Dennis for $180,000. Dennis wired send, lowest cash price, will give $165,000 cash. Charlotte replied, cannot reduce price. Dennis then accepted the original offer, but Charlotte refused to sell, claiming there was no contract. That's weird. Which of the following statements is true? Charlotte needs to get her head examined. The answer is number 2. Charlotte's reply to Dennis's first wire was, in effect, a counteroffer on the same terms as her original offer. So, Charlotte, yeah. So, number 2, Charlotte's reply to Dennis's first wire was, cannot reduce price, in effect, a counteroffer on the same terms as her original offer. So basically, she was putting out a counteroffer, but it basically was the same thing as her original offer. So what? Why won't she accept it? Don't know. 577, and the answer, let's see. A property is located in an area where most of the houses are connected to the sewer. The fact that the property in question is only connected to a septic tank creates a situation known as 3, a latent defect. So that is a latent defect because this property, it's in an area where everybody's connected to the local sewer, but this property isn't. So this is called a latent defect. Unless City Hall hates that particular owner. 578. On June 1st, Jim offered to buy Boo's summer cottage for $230,000, and Boo accepted. Since the cottage was on a secluded island, neither party was aware that on May 30th, the cottage was struck by lightning and completely destroyed by fire. Boo had no insurance and is seeking to enforce the contract. Which of the following statements is true? For 578, number 4. This is an example of common mistake and the contract is void. So, and why is the contract void? The contract is void because when they signed the contract on June the 1st, actually the cottage had already been destroyed on May the 30th, so they both made a mistake. So that's an example of common mistake number 4. We turn over to page 12, and we've got question 623. Bernadette has agreed to purchase Steve's home for $438,000. However, before the sale completes, she discovers that she has been the subject of an innocent misrepresentation, which materially affects the contract. Bernadette may go to court and ask for the application of which of the following legal principles? And the answer is 3, rescission. So let me read it again. Bernadette, she has agreed to purchase Steve's home for $438,000. However, before the sale completes, she discovers that she has been the subject of an innocent misrepresentation, which materially affects the contract. Bernadette may go to court and ask for the application of which of the following legal principles? And the answer is 3, rescission. She can try to, because she had, so as far as I know, rescission is after you've signed the contract, but something goes wrong. That's rescission. As far as I know, revocation is when you have not signed the contract yet. You're in the negotiation stage. 624. On January 1st, Abdul places an advertisement on CQXR radio station offering squash lessons for $30 per hour. Lois heard the ad and phoned Abdul on January 3rd and said, I want to take squash lessons, but I'm a student. Do you give a lower rate to students? Abdul said that he only had one rate of $30 per hour. Lois said she would phone back. On January 5th, Lois phoned Abdul and said she accepted Abdul's offer. Which of the following statements concerning Abdul and Lois is true? And the answer is 3. Lois's January 3rd call was a request for information, and Abdul's response on January the 3rd was an offer, and that is true. Okay? When Lois called on January the 3rd, that was a request for information. When Abdul responded on January 3rd, that was an offer. 683. Which of the following will not release an offer? And the answer is 1. The illiteracy of the offeree. That will not release them. Okay? If you're illiterate, That's not going to release you. But these other 3 things will release you. 2, the expiry of the specified time limit in the offer prior to acceptance, yes. 3, a counter-offer by the offeree, yes. And 4, revocation of the offer communicated to the offeree by the offeror. Yes, that will also release you, but not illiteracy, number 1. And we move to question 13, 690, page 13, question 699. Where no time period is stipulated in an offer, the offer 2 will lapse after a reasonable time. So where no time limit is stipulated in an offer, the offer number 2 will lapse after a reasonable time. What is reasonable? Who knows? Question 721. Which of the following statements concerning a corporation's capacity to contract is true? And the answer is 3. Any person may ascertain the legal capacity of a corporation to contract by reviewing its incorporation documents maintained at its official records office. So let me read this again. 721. Which of the following statements concerning a corporation's capacity to contract is true? And the answer is 3. Any person may ascertain the legal capacity of a corporation to contract by reviewing its incorporation documents maintained at the official records office. So anybody could just walk right in during office hours to the official records office and look at the incorporation documents of, as far as I know, any corporation. Question 750. If an offeror who has stated that the offer is open for 24 hours decides to terminate the offeror, number 2, must communicate any revocation of the offer to the offeree. So if an offeror who has stated that the offer is open for 24 hours decides to terminate the offer, boom, the offeror, number 2, must communicate any revocation of the offer to the offeree. Page 14, question 777. Which of the following will not serve to discharge a contract? And the answer is 4, a patent defect. All right, this will not serve to discharge a contract. Number 4, a patent defect. These other things will discharge a contract. 1, an agreement between the parties. Number 2, the concept of frustration. And 3, performance of the parties' mutual obligations. But number 4, a patent defect will not serve to discharge a contract. Question 783. The courts will never allow the remedy of specific performance where, number 3, damages are considered to be an adequate remedy. The court will never allow the remedy of specific performance where, number 3, damages are considered to be an adequate remedy. Okay, so the courts have already awarded damages. So because of that, they're not going to award specific performance. Make sense? Question 836. The doctrine of privity of contract, number 4, does not apply to contracts where an interest in land is created. So the doctrine of privity of contract, 4, does not apply to contracts where an interest in land is created. Question 839. Which of the following is not one of the 3 essentials for the formation of a binding contract? And the answer is 3, deposit. Which of the following is not one of the 3 essentials for the formation of a binding contract? The answer is 3, deposit. The other things like 1, consideration, 2, acceptance, and 4, offer, those things are essentials for the formation of a binding contract, but not deposit, number 3. And then we've got page 15, question 850. On May 3rd, Mary offered to buy Harvey's house. The offer was stated to be open for acceptance by mail or telephone until 2 p.m. on May the 4th. Which of the following statements is true? And the answer is 3. If Harvey makes any changes to Mary's offer prior to accepting it, Mary's original offer is terminated. 853. If Harvey makes any changes to Mary's offer prior to accepting it, Mary's original offer is terminated. And that is the answer. 875. Under the law of contract, which of the following is not an element of a misrepresentation by a seller that will entitle a buyer to rescind the contract of purchase and sale and claim damages? And the answer for 875 is number 1. The statement must be one of opinion. Under the contract of law, which of the following is not an element of misrepresentation by a seller that will entitle a buyer to rescind the contract of purchase and sale and claim damages? So the answer is number 1, the statement must be one of opinion. All right? That's not an element of misrepresentation. The other things are, statement must have induced the buyer to enter the contract. 2, 3, the statement must have been one on which a reasonable person would have relied. And 4, the statement must have been made by the seller knowing it to be false or recklessly as to its truth or falsehood. So all those things, they do entitle you to rescind a contract. But if you, number 1, the statement must be one of opinion. If you just give your opinion, that's not really misrepresentation. Question 877. Which of the following is false with respect to the law of contract? The answer is 2. The burden or liability under a contract may be assigned provided that the requirements of the Law and Equity Act are met. That's not true. But number 1 is true. Subject to some exceptions, only the parties to a contract have the right to sue or be sued for breach of the contract. That's true. Third party can't sue. And number 3, a contract which creates an interest in land is one of the exceptions to the doctrine of privity of contract. That is true. And 4, a statutory assignment must be in writing, must be absolute and unconditional, and notice in writing of the assignment must be given to the original promisor. And that's also true. But the thing that's false for 877 is number 2. The burden or liability under a contract may be assigned provided that the requirements of the Law and Equity Act are met. No, the burden or liability under contract cannot be assigned. You got to keep it. Page 16, and we're going to question 931. Which of the following does not relate to the topic of contract law? And the answer for 931, drum roll please, is number 1, depreciation. Depreciation, it doesn't relate to the topic of contract law. You got that? Depreciation. But all these other things, such as 2, consideration, 3, voidability, and 4, quantum merit, they all relate to the topic of contract law. And my last question is 958. Which of the following is true? Specific performance is, and the answer is 1, all of the above. 1, all of the above. So what are all of the above? A, an equitable remedy, which a specific performance is A, an equitable remedy which may be granted at the discretion of the court. Specific performance is B, often sought in cases of contracts for the sale of land. Yes. Specific performance is C, not granted by a court in cases where monetary damages are an adequate remedy. Yes. If they've already given money, monetary damages, they don't need to do specific performance. And D, a remedy for a breach of specific performance is D, a remedy for a breach of contract, requiring the terms of the contract to be performed. So basically what happens is somebody broke a contract, the victim brings it to court, the plaintiff, and then forces the defendant to do the contract. That's called specific performance. So answer is number 1, all of the above. And that's all we got, folks. Thank you so much for your